I'm going to sit in the front, so.
Oh, you'll sit at the front and take a picture while okay, fantastic.
The best thing to do is just let me email.
Thank you.
Thank you so much.
So nice to meet you.
Nice to meet you too.
You want us to kick off?
Yeah.
I can't say about other panels, but I know in the trade and investment world, it's a very prompt community, especially when hearings are taking place or events are taking place in Geneva, which tends to run on Swiss time. So we're going to start exactly on time. My name is Mark Wu. I'm the Henry L. Stimson Professor here at Harvard Law. For a brief period, I also served as the Vice Dean for the Graduate Program in International Legal Studies. So it's wonderful to see so many of you here. Welcome back. And it's my pleasure today to kick off our panel on international investment and trade. We have 5 panelists here. I'm just going to introduce them briefly, but you have their full CVs in your books. And I'm just going to go down the row here. To my immediate left, to your right, is Peter Bekker, who's the arbitration counsel and head of investment arbitration task force at CMS, followed by Minister Elizabeth Galdo, who served as the Minister of Foreign Trade and Tourism for Peru, followed by Ambassador Chang-fa, who currently serves as the permanent representative of Taiwan to the World Trade Organization and was formerly a justice of the High Court, the Supreme Court in Taiwan. To his left, to your right, is Caroline Richard, who's a partner of the Freshfields, working on investment arbitration based in Washington, D.C. And last but not least is Professor Alvaro Santos, who is based at Georgetown Law and who was intimately involved in the renegotiation of the U.S. Mexico-Canada agreement. So I'm going to kick off our discussion this morning. I think all of you are here because of your interest in either investment arbitration or trade. But I'm sort of going to start by setting a big picture, which is that we know over the past quarter century, we've gone through this unprecedented period of globalization. We've seen rapid growth of cross-border trade, immense flows of foreign capital and investment. And along with all this, not surprisingly, has been a proliferation of disputes. Some of which many of you have been involved with personally. And what we also know is that along with this proliferation of disputes, while we've seen millions or hundreds of millions of people lifted out of poverty because of these trends in trade and investment, the distribution of gains from all this has been very uneven, both within and across countries. And this has sparked a tremendous populist backlash against the institutions that are driving and overseeing the forces of globalization, including those that oversee these disputes. So we've seen over the last 8 years in particular, populists call for dismantling these treaties, and we've actually seen countries withdraw from either treaty arrangements, the most notable, of course, being the United Kingdom, but also calling for withdrawal from the institutions that support these forces of globalization. But yet, despite this backlash, we continue to see the number of investment, arbitration, and trade disputes increase, or at least remain steady, with the exception of the WTO appellate body. And we continue to see negotiators forge new treaties with robust dispute settlement provisions. So I want to ask our panelists if they can help sort of shed some light on how we should try to make sense of these seeming contradictions. Peter is somebody who's been involved intimately in these disputes and also responding to some of the criticisms which have come out, including that from my former colleague, Senator Warren, and so forth. Why don't you kick us off on how you see this from the investment world?
Thank you, Mark. I had a real pleasure to be back here, and I was telling Mark, this was my favorite room when I was here 34 years ago. I spent a lot of time doing research on what would become my PhD. And Detlef Wacht, the late Professor Wacht, served on my PhD committee at Leiden University in the Netherlands, so it brings back a lot of memories. I've devoted my life to international investment law and public international law in general ever since I graduated in '91. First starting at the International Court of Justice, where I spent 3 years. So I think I can speak with some authority about public international law and maybe investment law in particular. I actually was the first instructor to teach investment arbitration at Columbia Law School. And that was only in 2007. Now that indicates there's a lot of education to be done. So the educating part, I think, ties into what I was going to say in my first comments. And Professor Wu actually had a sentence in his remarks that he shared with us to get us thinking about what we would discuss on this panel. And one sentence read as follows: populists who have called for dismantling these treaties and are withdrawing from these institutions have gained political power. And funny enough, I immediately thought of an op-ed piece by Senator Elizabeth Warren, and she was a tax professor when I was here. And so she transformed herself into a politician. Unfortunately, she was ill-advised to write a piece that has no foundation in practice or indeed in international investment law and arbitration. And so it was really a sort of a rally, a call to arms. And the title was "The Trans-Pacific Partnership Clause Everyone Should Oppose." So clearly a rallying call there. And this Trans-Pacific agreement is a free trade agreement, 10 countries, United States, Japan, Singapore. And she claims that investor-state dispute settlement really would undermine US sovereignty. Now, that kind of statement shocks the conscience of a public international lawyer because, as arbitral tribunals have pointed out, concluding treaties is an exercise of sovereignty. It is not a limitation of sovereignty. So I think right there, she went off on the wrong foot there. And then she says, well, with ISDS, the company could skip the US courts and go before an international panel of arbitrators. If that seems shocking, buckle your seatbelt. ISDS could lead to gigantic fines, but it wouldn't employ independent judges. Oh my God. So arbitrators cannot be neutral. As a matter of fact, they are picked because they are impartial and independent. She said that these are basically pseudo courts. And then she asked, what's so wrong with the US judicial system? Well, if you have been in the US judicial system, if you have been before a state court judge or a federal panel on an international law case, you would question what she just said, and I've been there. She also said that this ISDS phenomenon, independent arbitration, bypassing the courts, would offer a free taxpayer subsidy to countries with weak legal systems. And the only winners will be multinational corporations. Those are her final words. Well, she's got her facts wrong, because if you look at statistics, and this is what we call empirical evidence, what scholars use, right, as part of their research methodology, countries that defend these cases win more than the corporations that bring the cases. That's just a fact, at least from the known cases in the World Bank Arbitration Institution. ISDS protects investors abroad, overseas, both US and non-US. And as a matter of fact, the United States has concluded more than 40 bilateral investment treaties, including with, I think the latest with Rwanda. A US investor wouldn't want to go into the courts of Rwanda, not because they're not independent, but they may not be competent. They may not know about a sophisticated investment. So how would they be able to provide justice? So I think I will leave it there as my preliminary remarks.
Mr. Galdo, as somebody who's been intimately involved in this as a minister, but also as a politician, any thoughts?
Sure. First of all, it's an honor for me to be here. Thank you for the invitation. When I joined the program, the Harvard Law School LM, in 1999. I was expecting, I was eager to broaden my legal knowledge beyond Peru. But also, something else happened. I got pregnant during that year. So it's always very nice. It's a joy to come to Boston because my daughter was born here, and in my professional career, it was a great year because I grew academically. It was also a challenging because I have to learn to manage time, and I have the support of the community at Harvard Law School, and I am very grateful for that. And coming back to contradictions in globalization, I agree with Professor Wu. The contradictions in globalization stem from its multifaceted impact. While globalization has spurred economic growth and lifted millions out of poverty, the benefits have not been evenly distributed. This unevenness had not led to satisfaction, and backlash against international institutions perceived as favoring certain groups of nations. However, the steady number of investment arbitration and trade disputes, along with new treaties being forged, indicates that countries recognize the importance of structured frameworks to manage international relations. They continue to engage in these mechanisms to protect their interests and resolve conflicts efficiently, essentially despite criticisms. The underlying need for cooperation and dispute resolution in a connected world persists. I was telling Professor Wu that Peru this year is host of the APIC Forum. So 21 economies have been meeting. I had a meeting with the ministers of trade in Peru. I was a chief, and I have the chance to meet Ambassador Wu, who is actually the representative of trade, the main counselor. And while we were talking, we realized that we have something in common. We were at Harvard Law School at the same time. She was a JD, and I was an LLM candidate. And she told me, oh, I was so jealous about you, the LLMs who also look so fun and relaxed. And I was so miserable, studying all the time. Okay, but now you can see where she is. So that is also something that I want to highlight about Harvard, the networking that you can get, and you can find very important people, as I have heard before. Here in Harvard, all of us are leaders, and I cannot agree more on that. That are my first thoughts.
Great, thank you. And I think for those of you who know Ambassador Tai, I think you can see she's certainly that studying has paid off, and she's taken to great heights. Ambassador Law, you've seen this from so many different angles, as an academic, as an arbitrator yourself, and now as an ambassador. And as somebody who's looked at this not just from trade, but also international health, and thinking about all of these impacts and globalizations, how do you make sense of these contradictions?
Thank you. Thank you, Mark. Before that, let me thank Harvard Law School to invite me to this very warm event. It brings me a lot of memory. Peter just mentioned before the start of this session, this building was used to be, this part was used to be a library for international law. I remember each S.J.D student was assigned with a desk at that time each day. I gave myself a target at least to write something in order to graduate. So that was a very memorable days. I see this this whole question from three. I pick up three elements. One is the globalization and the uneven distribution arising from the result of globalization. And the second is about the dispute, the proliferation of dispute. And third is about dismantling international treaties or international regimes. The globalization, the term, has not been used, has not been a favorite term in the real world. In Geneva, we do not use this anymore, sadly, or there could be different perspective. Mainly because of uneven distribution of the benefit arising from globalization. We talked a lot more about the disadvantaged people. We talked a lot more about how disadvantaged countries between WTO members or disadvantaged people within a WTO member. How are we going to deal with that? And therefore, further liberalization has not been in the agenda for quite some time. Of course, there are some results arising from this. For instance, if we are talking about how to address the inequality between countries, there might not be consensus on the approach or on the real need of countries having been granted to enjoy special and differential treatment. But sometimes we get progress, but most other times we have difficulties of moving any topic forward. In terms of dispute, I've seen dispute, of course, trade dispute within the WTO, being composing different types. Some of the disputes genuinely arriving from the implementation of applications of WTO rules. For instance, if there is a breach of SPS commitment, SPS rules, and therefore there could be a genuine issue about whether the rules, whether the scientific evidence has been shown. But more and more disputes arise from things having a lot to do with political tensions. For instance, in the last several years, there are quite a number of disputes having to do with countries exercising its economic power, economic coercion, we call it this way, to achieve certain political purposes. And of course, there could be other, not necessarily having come to the stage of dispute, but a lot of differences. For instance, countries accusing each other to subsidize, country accusing each other not to counter or to retaliate or to counter-retaliate with tariffs. So there are different types of dispute emerging, and these different types of disputes are not actually the ones which the WTO dispute settlement is not capable of dealing with. This is very very negative development, to put it this way. In terms of dismantling international treaties, basically, I would say there are new development. Because of this new development, countries are not being satisfied with the sufficiency of the current rules to accommodate their domestic need. For instance, whether the current rules are able to accommodate the so-called national or essential security need. If not, then what? Then I just avoid following the rule. For instance, there are issues about the current system, especially on the appellate body, on the reinstallment or to put it back of the operation of the appellate body. And of course, there is a strong sense in the United States about the appellate body not being in good operation, and that run against the interest of the U.S. So these are the developments apparently having a lot to do with the whole overall operation of the international multilateral system. So these three developments, I think they occurred parallelly, but they are related, but not necessarily they are because of one or the other, so that the other happens. Thank you.
Thank you. Caroline, over to you, especially as somebody who's been literally, as you were just mentioning to me, literally in the jungle, in the weeds of all of this. Thoughts on these contradictions?
Yeah, let me give you my perspective. So I've been practicing investment treaty arbitration, focusing largely on Latin America for the last 20 years. And ever since I started practicing, people have been predicting the demise of my profession. But I'm still here, right? And I graduated from Harvard Law School in 2006. There was no investment treaty arbitration class. I studied trade. And I joined Freshfields in Paris because I actually joined the Latin American investment arbitration team. We had 14 cases arising out of Argentina's 2001, 2002 crisis. This was really the first big series of cases that were going to be that effectively developed investment treaty law as we understand it now. And I was so excited because I have some Latin American background. I'm Canadian and I'm French Canadian. Anyhow, so this is fantastic. And just when that happened, Hugo Chavez stood up at a conference of the ALBA countries and encouraged everyone to exit the ICSID arbitration system. ICSID is the International Center for the Settlement of Investment Disputes. It's an arm of the World Bank. And everyone said, oh no, right, this is the end of it all. In the end, after that speech in 2006, Bolivia denounced the ICSID Convention in 2007. Ecuador did it in 2009. Hugo Chavez eventually got around to it in January 2012. Bolivia and Ecuador terminated many of their effectively all of their investment treaties in the years following that. But that's pretty much where it ended, right? And for Venezuela, Ecuador, and Bolivia, these denunciations and terminations happened in the context of a pretty extreme political and economic shift in those countries. And, the discourse, in those countries against investment treaty arbitration has been, largely misinformed, not always very logical. For example, for Venezuela, denouncing the ICSID Convention when effectively all of your treaties provide other arbitration rules and forums as an option is really a distinction without a difference, right? ICSID is not the boogeyman. ICSID is just, a building on Connecticut Avenue in Washington, D.C., where there are people who forward emails and, keep hearing rooms stocked with coffee and the like. ICSID does not make substantive decisions. The ICSID Convention contains no substantive standards. So it's sort of like shadow boxing, to complain about ICSID. And, the rhetoric tends to be simplistic, and I think Peter kind of referred to some of the criticisms that aren't really borne out in the data. But really, although that sort of rhetoric against the system gets a lot of airtime, it's not really representative of what's happening in the world of investment treaty arbitration, either globally or in Latin America, right? If you look at the two countries that have the most cases, actually the country with the most cases is Argentina. Argentina had 65 cases against it. It hasn't denounced the ICSID Convention. It hasn't terminated any treaties. Venezuela, although it denounced the ICSID Convention, has many cases against it, only denounced one treaty, which I think it did with a rather logical basis. It said, we're terminating the Netherlands-Venezuela treaty because it is effectively being used as a conduit for American companies, largely all the oil companies that Hugo Chavez expropriated in the mid-2000s, to bring claims against the state. It's not really about Dutch investment per se, which is, again, you can agree, disagree, but it's a logical justification. Then you have Peru, for example, which is a champion of ICSID arbitration. And there was a few years ago when President Castillo had made some disparaging comments about ICSID and investment treaty arbitration, but that was, I think, a blip in the otherwise, consistent, pro-globalization, rule of law stance of Peru. And, we've been seeing lots of new treaties being signed. Ecuador just rejoined ICSID in 2021 after exiting it in 2009. So yes, there is that push and pull, but the pull away from the system, I think, has, at least in Latin America, has really been in these extreme circumstances. And otherwise, I'm happy to tell you I still have a job and still have lots of work to do.
For those of you who have not followed it, you'll be happy to know that we now teach multiple courses on investment arbitration each year here, and we have a very robust student organization focused exclusively on international arbitration. Professor Santos, over to you. You have a unique perspective in the sense that from an academic perch, you highlighted some of these uneven distributions and even some of the critiques, but then you had a chance to actually put these into practice for your government. So how do you make sense of what we see going on today?
Thank you, Mark. First, let me say it's really a pleasure to be back here. As Ambassador Law, I was reminiscing about this building where I think we had moved up a little bit, so we had offices around with beautiful windows. And we spent a lot of time talking to each other as doctoral students, long nights and long days debating ideas, and then also helping each other prepare for presentations, oral exams, and so forth. So much so that a JD friend of ours said that S.J.D stood for sitting just down, because that's a lot of what we did while we were here. So to answer your question, Mark, I don't see necessarily a contradiction. What I see is different paces of change. And so maybe one or another way to think about this is we can think about an axis that is basically the timing, or at what speed the break with the traditional model of globalization takes place. So it could be quick or it could be gradual. And then at what level is the change happening? It could be at the level of narrative or at the level of agreements and policies. And so if we start with the level of narrative, I think there's been a very quick change in the way we see the discursive practices now coming from governments and also in scholarship, away from efficiency and free trade lifts all boats and it's a win-win scenario, to concerns about workers and working conditions. First, concern about national security, and so a clear effort to try to increase productivity at home of certain strategic goods, a concern about climate change and energy transition, and a concern about the economic competition with China. And so these are permeating all the new policies and focusing now more in the United States, but also it's true in Europe. Policies and agreements are now being basically taken on these narrative concerns and are being reshaped by them. So they matter. At the level of policies and agreements, I think we see a different pace, and that's where it might seem like a contradiction, but there's just different speeds at which these changes are occurring. So both in the Trump and in the Biden administration, we saw changes in traditional policies, like an increase in tariffs, not just to China, which were kept by the Biden administration, but also to allies on goods that were deemed strategic, like aluminum or steel or other goods. And then we saw, as you mentioned, the renegotiation of NAFTA, where we have a new agreement that, even though it has some continuities with NAFTA, it also has important changes. And one of them is a dramatic reduction of the investor rights and ISDS between the US and Mexico. So the elimination for most sectors of indirect expropriation, fair and equitable treatment, full protection and security clauses that have been quite controversial in the adjudication of these treaties. And then no ISDS between the US and Canada. So that's an important change. On the other hand, there's also a new mechanism for labor enforcement on freedom of association. We've seen more than 20 cases. This enforcement mechanism is facility specific. It has real bite and sanctions on the companies that are violating those rights. It has problems. It's, for instance, very asymmetrical, so not reciprocal. It's mostly about violations of rights in Mexico. So we see a lot of disputes there, but it's a different kind of dispute than the ones we were seeing before. Of course, the withdrawal of the US from CPTPP, which was the signature agreement of the Obama administration. So we see clear changes in kind. And then I think we also see, as Ambassador Lau mentioned, trade disputes that are arising from these new trade policies, right? So again, some disputes between countries that are also of new interest because of what they're responding to. And finally, we have the disputes of investment claims that my colleagues have referred to. And in that regard, that probably is more of a continuation and some gradual change, because they are basically disputes brought by private parties against governments. And so to the extent that the regime changes, we will see, some modifications there. I guess I want to take a moment to just respond to some of the comments of my colleagues. I really appreciate the work they've done and their perspective. But I think it's important to recognize that, there's a re-examination of how the investment regime has worked. Whether it's not a question of sovereignty, I agree with Peter on that. It's a question of whether the regime is serving the purposes for which it was designed, right? Whether it's actually creating more foreign investment in developing countries, and whether that investment is resulting in development and better economic outcomes. And there's real concerns about the ways in which the regime has moved forward, concerns that have to do with the magnitude of the claims that, states are facing, claims that now amount to not millions, but billions of dollars. They can have a real impact in their fiscal budget. There's also concerns about regulatory chill and about the interpretation of these agreements in a way that could undermine the policies of states for the public good, whether it's in public health or the environment. So much so that the slogan to try to combat this practice is the right to regulate. So the idea that states have to claim that they have a right to regulate tells you something of how they experience the regime. Now, this is not to say that all the complaints about the regime are well-founded or supporting evidence, but there's so much concern that countries now under UNCITRAL, the United Nations Commission for Trade and Investment, are now making proposals that go from how to regulate the practice of arbitrations. You know, arbitrators don't have a general code of conduct that's sort of appealing to many countries. There's concerns about the practice of double hatting, where arbitrators are arbitrators one day, but counsel, you know, in other cases. So things that could be really, I think, reform and would be good for the regime. But then also concerns about what would be the policy autonomy of states to basically be able to regulate in some areas without having to worry about what they conceived as undue constraints on that ability, right? And so I think this is an area that's really, there's valid perspectives on both sides. There's a really good debate to be had. We, just a small advertisement, the center that I direct at Georgetown called CAROLA has a website on ISDS in Latin America it's very user-friendly, all the data and statistics about the amount of cases, the number of disputes, how many have states won, how many have companies won, in what areas, and all of that. So you can also basically make up your mind about what you think. But all of this to say, I think there's enough ground to think about potential changes that could be positive, that don't have to be about dismantling the regime or getting rid of it altogether. But I think that there are really important concerns that need to be addressed.
Great. So I'm going to pick up on that theme. I'm going to just toss an open question out to the panel. I think you've heard from this panel how these regimes are in a state of flux. And indeed, globalization itself is in a state of flux. Now, everyone on this panel sits in multiple communities, whether as a practitioner, as an arbitrator, as a diplomat, as a negotiator, as an academic, and so forth. And you participate in these communities in different parts of the world. Latin America has come up multiple times, but also Geneva, also different parts in Asia, which is really a driving force for much of this globalization, and Africa, where we've seen these trends in terms of the AFCFTA and the Continental Free Trade Agreement really sort of drive integration at those regions. What are the key issues that are surfacing in the communities in which you participate, and are these communities actually working with each other to try to deal with these issues that have surfaced in your responses and to think about how to reform these regimes, or are they really talking past each other when it comes to dealing with these challenges? And are we having the same conversation or different conversations across regions? So I'll toss this out as an open question to the panel, and feel free, anyone who wants to jump in here. Peter.
So I do wear multiple hats, but not the double hatting that is now criticized. So I'm not sitting as an advocate and an arbitrator. I'm a part-time professor, and most of my students, and certainly my PhD students, are from Africa. And some are studying overseas, in my case, at the Center for Energy, Petroleum, Mineral Law and Policy at the University of Dundee in the United Kingdom. They are paid by the oil companies that are the concessionaires for the states. So there's an educational benefit. My students are interested in things like community development agreements, which is something that is now part and parcel of new investments by oil and gas companies, where they basically earmark a certain amount per year to help develop schools, improve education, infrastructure. So community development agreements are a thing that is popular among African students. Now, the way they go about educating themselves and writing about it in their PhD thesis is by doing comparative studies. So they look at Australia, how's the mining industry been there and with community involvement. Canada, how are some of the indigenous populations benefiting from these foreign direct investments. So I think that is a salutary development where these developing countries are looking to more developed systems so as to profit from some of the money that's earmarked. I'm currently advising the government of Uganda, which is an emerging oil-producing country. It's not a coastal state, it has lakes, right? But lakes also have deposits in the form of petroleum. And the European Parliament has told Uganda's concessionaire, Total Energies, French, you cannot invest there because, of course, fossil fuels, dirty oil, and then there's going to be a pipeline to through Tanzania, and so farmers will be affected, and are they compensated enough? And I think if Total would withdraw, the money also would be withdrawn. That helps people like me advise the government. And so I do workshops. I train some of the people in the regulatory authority, in this case of Uganda, some of the people in the national oil company, and they profit from these kinds of arrangements. So I think there's hope, but it's under pressure.
In the communities I have been part of in the government, as international trade, working also in digital education, and also involving in women's entrepreneurship. Some of the key issues that we are talking about is first, digital inclusion. Bridging the digital divide is crucial. Efforts are being made in my country to provide access to technology, especially for education purposes, to underserved populations. There is still no internet in a great part of the country. You cannot believe it, but it's like that. I have worked in digital educations at the Telefonica group, where I have seen a lot, and I know how valuable is digital education for the students, and also, of course, for trade. During the pandemic, electronic trade was very important, and now for everybody. Before it was not like that. Since the point of view of women's empowerment, promoting gender equality in commerce and entrepreneurship remains a significant challenge. We are discussing the constraints that women have that don't have men, and we want to remove barriers such as financial constraints and limited networking opportunities. Also, women also have other tasks, taking care of the family. So including women in commerce is also a task, and we are discussing about that a lot. Other key issue that we are discussing is about trade facilitation. Okay, we have a lot of free trade agreements, but let's make it work. So it's very important to facilitate, to simplify trade processes to benefit all market participants. It is a continuous goal requiring collaboration across nations and sectors. These communities are increasingly working together, recognizing that collaboration yields better outcomes. Forums like APEC that I mentioned before facilitate this dialogue, and it's very interesting to listen to all the perspectives from different countries. However, differences in priorities can lead to instances where parties talk past each other because of the difference. So it's very important, continuous communication and shared objectives. They are key to overcoming this. Thank you.
I was very fortunate to have the opportunity serving the government, serving in different positions. Before coming to Harvard, I was a practicing lawyer for several years and earned some money to be able to come. Of course, I got a scholarship to support my living here. And I taught after I graduated from Harvard. And I had the chance to work for the Fair Trade Commission, which is in charge of antitrust law in Taiwan. I happened to have the opportunity to serve as constitutional court judge. And then being the panelist of the WTO dispute settlement panel and being the negotiator. So all these issues, I think they are mutually supportive. They need a lot of creativity. They need a lot of problem solution orientation. The way that you deal with the issues, basically, the ultimate purpose is to find a way to resolve the issues, no matter whether it is constitutional or otherwise. But of course, sometimes you just have to remind yourself, when you find solution, you need to compromise. When you compromise, to what extent you can compromise, not to deviate from your basic value. Talking about the very important point about the discussion or negotiation, whether they are really talking to each other or talking past each other. I find different situations. Sometimes you just cannot understand why is that the point you make was not listened. You know, in international settings, a lot of times you find people sitting there, the first reaction is to oppose, to find problems, to be very suspicious about anything that you raise. I'll give an example. There was a discussion during the first stage fisheries subsidies negotiation. We call it Fish 1. I proposed a clause concerning dispute settlement procedure. You know, in the WTO, there are violation complaint, non-violation complaint. Even if you do not violate any commitment or any WTO obligation, you can still be sued by any other country because of their interests being impaired. I said this is not applicable to the fish discipline because everything that you commit has been put into the clause very specifically, very clearly. So there shouldn't be any room for non-violation complaint. And some developing countries, this is supposed to be good for developing countries, and some developing countries will very strongly oppose my suggestion, my proposal. So they just didn't listen. They start by being very suspicious about why is that you propose this clause. Another example is more positive. Also during the Fish 1 negotiations, when I went to Geneva in the first year, there was a very important issue about how, if there were at that time the fate of the negotiation was not uncertain, if there were a document, an instrument being concluded toward the end of the negotiations, then whether the instrument should be a standalone agreement or should be an agreement attached to the existing WTO subsidies agreement, because we are talking about fisheries subsidies. It seems to be this has to do with subsidies agreement. I wrote 2 discussion papers circulated among countries, and trying to explain this is not right to be attached to the subsidies agreement, because the respective natures are very different, totally different. Subsidies agreements are about preventing distortion of production and trade. This is prevention of distortion of environment. This is not about competition, nothing to do. Of course, there has something to do with economic activities, but nothing to do with the competition. And I prevail. So that is something. Sometimes you find a satisfactory result arising from genuine discussions. Of course, we still have problems. We do not have trust in Geneva. So building the trust is, of course, the most important and most difficult one for us to do anything. Thank you.
Well, on my side, as an investment treaty lawyer, as a wannabe academic, because I'm an adjunct professor in my spare time, I'm seeing developments that I think have been touched upon by other panelists here as well. And what I'm seeing a lot of these days is ESG issues that are surfacing and leading to international disputes. And when I say ESG, my corporate colleagues at the firm kind of roll their eyes because ESG has sort of fallen out of fashion, at least in the investor world. But in the investor state world, it's alive and well. The E has been around for a long time. Ever since I've been practicing investment treaty arbitration, there's been a lot of environmental issues that crop up in those cases. Same thing with the G, governance, right? World Duty Free v. Kenya, which is one of the poster cases for, corruption in international investment, came up a long time ago, and there was a period where it was a very sort of trendy defense. It was coming up in a lot of cases. I think the newer development now is the S, especially in Latin America. There's been a big development in terms of concern over social license, indigenous peoples' rights. In my cases at the moment, almost all of them deal with social issues, community consultations, illegal mining, social license, etc. And all of this kind of comes back, I think, to an issue that Alvaro was mentioning, which is the issue of, are investment treaties creating regulatory chill and impeding developments in the ESG space. And as a practitioner, and admittedly as a practitioner who mostly represents investors, I don't always find the argument about regulatory chill to be very compelling, right? And I'm going to be provocative because otherwise this won't be fun. To me, investment treaties contain all sorts of fancy international law lingo, but ultimately they're about the rule of law. That's all it's about at a very high level. It's about respecting commitments that governments have made to investors through contracts. It's about complying with the laws on the books. Often the examples that are given of cases that are creating regulatory chill are, it's not about regulatory chill at all. It's just about rule of law. And to just mention one case to be specific and not just speak theoretically. One of my cases, Ecuador versus Colombia, which I'm sure you're aware of, is pretty illustrative of the issue. You have a mining company signed a concession agreement with the state for 20 years, was required to invest, right? It's not just, you don't just get the right to mine, you have the obligation to mine when you get a mining concession. It spent $300 million over a period, all approved and in fact required by the government. And then, the government ultimately, mix of government and courts, et cetera, decided to ban mining in the area where the mine is. Does the state have a sovereign right to do that? Absolutely. But is the investor entitled to compensation in those circumstances? The answer under investment treaties would be yes. But that would also be the answer under domestic law, right? Where, if you have a contract and that contract is then taken away, even if it's taken away for laudable reasons, change of policy, we actually don't want to do mining in this area of the country, we want to do ecotourism, fine, right? But it comes down to the rule of law. And I think that's where we're seeing tensions frankly, across the international law gambit, this tension between all these transitions that are taking place and, the need to respect the rule of law.
Thank you, and I really appreciate Caroline's perspective, because otherwise it wouldn't be fun, and also because you so wonderfully represented the perspective of the investors and the law firms who support this regime. Just on the other side of the equation, just so that you have the complete picture too, I would say there's been good scholarship actually showing how the Philip Morris case against Uruguay on the regulation of tobacco, for example, advertising, did have some impact on what other countries were, willing or not willing to do. The same case with Australia. There's ways in which, and there's been, interviews to public officials that have basically sort of convey, how they're thinking about these issues. So the extent to which some countries stop doing things that they think would be desirable, but are concerned about the potential implications that would have with investor claims. And just going back to the question of regulatory autonomy, it's not just regulatory chill, it's also the way in which, for instance, indirect expropriation has been interpreted, right? So what are the bounds or the boundaries of a taking, and how tribunals are interpreting this? So it's not just about the rule of law in the sense that, these standards change, and also it's been not very consistent. There's no appellate court in the investment regime, so tribunals can come out with different standards. This is, the motivation for an effort to try to create, in the position of the EU, a multilateral investment court, or to basically give a little bit more coherence to the regime and provide more consistency. On the rule of law, again, there's been voices of practitioners and scholars who actually claim this regime looks nothing like the rule of law, like George Cahale from Curtis wrote this article called, ISDS, the Wild Wild West, of international arbitration, and he basically alludes to, the rules of evidence, the way that damages are calculated, and so forth. And so there's I think, a really good debate to be had about whether this is in fact a regime that exhibits the features of the rule of law, and in what way is it helping countries achieve the goals that they thought they were going to achieve when they signed up to this regime. But so happy to keep talking about this, but just to be more directly to your question, Mark, I mean, so I've been an academic, and I've also had the privilege to participate in the USMCA and have been in touch with public officials in Mexico and other Latin American countries. One issue that I see, one concern is how to make sense of the changing nature and architecture of the global economy in a way that could be beneficial for developing countries, right? So the changes we're seeing in the US and Europe are the new industrial policies that these countries are taking that are changing the rules, are promoted as good for everyone who joins, right? And I think there are important distributional concerns for developing countries. You know, if you think about critical minerals, digital trade, you know, labor enforcement. This, by the way, is a project that I've launched at Georgetown under the sponsorship of the Hewlett Foundation, called Latin American Political Economy and Globalization, LAPEG, with a colleague from the University of Valparaiso in Chile. So we're looking at these issues because we basically think there are important opportunities for developing countries, but are often these concerns are not really taken care or addressed when we're discussing in the North how should the global economy look like. And we run the risk of creating some of the same problems and leaving unattended these potentially negative consequences for developing countries, right? So if you think about critical minerals, there's a real risk of a new extractivism. If you think about digital trade, well, there's really clear concerns about who these new rules are going to benefit and what will be the opportunity of developing countries to take advantage of the digital economy and so forth. So basically, the slogan that I would say is we need to prevent a regime that is post-neoliberalism at home, but neoliberalism abroad. How can we think about a new global architecture that really takes into account the concerns of workers, but not just in the US, climate change, common problems, and the aspiration to better living conditions in the developing world.
So I hope the last hour is giving you a sense of just how much this world is in flux, points of actual discourse that are happening, but also points of disagreement. So let's throw it open to all of you. Let's capture a round of questions. And then we'll let each panelist address whichever question they might like. So if you have a question, please raise your hand. Please wait for the microphone. And then if you could also just state your name and...
Thank you very much for the privilege of asking the first question. They're two quite specific questions. They're not connected. First, the OECD has proposed a revision of the tax jurisdictions across the world so that instead of residence as being the basis for tax, it would be digital services. The proposals are Pillar 1, Pillar 2. Pillar 2 is global minimum tax, which is due to come into force next year. And subsequently, it is likely to lead, or may lead, to a reassessment of jurisdictions so that in relation to digital services taxes, the basis of jurisdiction would be more likely to be market jurisdiction than residence. Now, this obviously invokes the position of investors, because investors obviously often choose to be resident for tax purposes in a low tax jurisdiction and may find themselves in future faced with the new global minimum tax or a tax under the reallocation of tax boundaries jurisdiction. And what I wanted to ask is whether any of you thought that engaged what you've been talking about under investment treaty arbitrations, because these are investors who may well have an axe to grind, as it were, and whether you saw any scope for that. That was question one. Question two is one which has engaged us in London, which is whether there should be any special responsibility by arbitrators, whom, as Peter has said, should be of high quality and thoroughly independent. Should there be any obligation on them to look for signs that the process is being compromised of arbitration is being compromised by corruption?
And can I ask you to identify yourself? So,
Mary Arden.
All right. Okay. A question up front here. We're just going to capture all of the questions before we. Up front.
Thank you. Good morning. I have a couple of questions, but I just gonna highlight the first two. I'm sorry, I took notes. I'm a professor of law myself, and I'm a judge, so I have questions about corruption and a couple of things. But what I'm finding is that I'm from one of those countries that are labeled as LDC, such as Liberia, West Africa. So I'm finding that arbitration, it's sort of a soft landing and a wiggle room for many multilaterals who want resources from countries such like mine, but abhor the legal system. Then you find also, in terms of abhorring the legal system, they rush to arbitration, but because law is particularly jurisdictional, countries such as mine are not represented by their own lawyers, but then again, are represented by lawyers from those countries who you're already having an issue about the extractive industries, and they're the ones who are representing you in these kind of multilateral forum. The other thing I wanted to talk about and maybe modify that comment by Professor Bekker, he said something about community development, and for my notes, I'm like, okay, it's like AKA corporate responsibility in foreign direct investment. So it's not that, I don't think it's that one wants to profit from the money that's estimated, but rather you want to profit from your own natural resources that are being extracted, and the corporate responsibility part is not being fulfilled. So for example, I have Firestone in my country, and it's been there for quite a long time. And sometimes you think that the indigenous people want to expropriate. I think I heard Professor Santos talk about that. But at the same time, they're there. And when you look around in terms of community development, there's not much that's going on. So it seems to me that everyone is involved in this corruption that she spoke about. So you're corrupting government officials who are supposed to be protector of these natural resources. And then because you're corrupting them or they're being corrupted, so then they close their eyes, and then the corporate responsibility or the community development piece is not being fulfilled. So I just want us to, I just want your thoughts on that, because oftentimes it is said that we are not respecting the rule of law, or sometimes these countries just want to expropriate, but I don't find rule of law exclusive to community development or corporate responsibility on part of the multinationals. Thank you.
Right, thank you. One last question. There are two questions. If you could, again, identify yourself and then state your question succinctly. Just want to make sure we try to keep it within time.
Thank you so much. Good afternoon. Thank you to the panel for this very interesting discussion. My name is Tatiana Payosova. I'm an LLM of 2018, also former student of Professor Makwu. I have one question to the panel. It's a more general question. So we have discussed that we are now living or experiencing interesting times for international trade and ISDS legal regimes. And there has been essentially a questioning of the existing tenets of both international trade and ISDS. Typically such interesting times or times of flux are challenging, but they might also offer opportunities, and the word opportunities has been mentioned by several panelists today. So I would like to ask the panel to reflect on what specific opportunities do these interesting times offer. Thank you.
Okay, and one last question in back.
Firstly, thank you so much for such an interesting panel and such interesting discussions in general. My name is Carolina Monroy-Rosso. I'm a current student of law. And I have two questions. So one is more general. Firstly, observing your vast international experience in so many different realms of the law as well as different countries, I wanted to ask in general, what you would all say have been the primary ways that have been seen to work to promote and increase foreign direct investment, international trade and commerce, and just transnational commerce in general to promote the economic development, especially that developing nations wish to have, while still maintaining sovereign interests and national state interests. So how does this get balanced in the best way in your perspective? And my second question is more regarding arbitration in general. How would you say the principle of competence has been evolving, and how has this like UNCITRAL model law been respected both in national courts as well as the tribunals themselves? Thank you.
Okay, thank you, everyone. I'm just going to quickly recap what I captured as 7 questions. Question on tax, question on corruption, question on representation, a question on corporate responsibility, on what types of opportunities, balancing development and sovereignty, and on competence. So I'll leave it to our panelists as we wrap up to take any, hopefully not all 7 of those questions, but any of those you wish to reflect upon.
If I can just respond very quickly. First to Lady Arden. We actually were at a conference earlier this year. We were in the same room in the Peace Palace. We are fellow members of the Permanent Court of Arbitration, which is the oldest standing arbitration institution. So on tax, I don't have a substantive answer for you, but I think it's very important that you raise the tax issue because we're talking about investment here, right? And criticisms of investment regimes and investment arbitration. But tax is more important for investors than having investor-state dispute settlement. How do we know that? Studies have been done. I remember one that was done by the Economist Intelligence Unit and Columbia University, and they quizzed, polled maybe 200 executives or so, and they said, how important is having an investment protection treaty with arbitral provisions? Only 23% said that is of interest, that they think about this in their risk assessment. So I think tax and accounting are probably more important than the things that we are discussing here. So let's not forget about tax. Then about the arbitrator code of conduct. An Austrian LLM graduate, Michael Weibel, couldn't make it today. And he did a very interesting study at the University of Cambridge, where he and a fellow scholar looked at the background of arbitrators, and I think maybe counsel in general in investment arbitrations. Now, these arbitrations are governed by public international law in most cases, right? It's treaties, international law. Lo and behold, only 27% of the people that they looked at, having been involved in these cases, have a background in public international law. So states, corporations, they put people on panels to decide cases where less than 30% have a background in public international law. That is, they studied it, they have a PhD in it, or maybe they have a real practice in it. I find that shocking. I think that's an element of competence. As a matter of fact, Rule 1 of the model rules here in the United States, it's about competence. You cannot represent a client unless you're competent. And that, I think, is a relevant question to ask. Are these people really competent? And I think more arbitrators should ask themselves that question. Am I competent to decide this bet the country case? On CDAs, very quickly, they are a payment. So they come on top of the investment that is made by an investor. So it is extra money, if you will, that goes from the profit base. And in that sense, I think it's a good development in that it is money in the hands of locals to improve their schools, their roads, their bridges, and lift them, in that sense, out of poverty by enabling them. So it's about capacity building. On the opportunities from the 2018 graduate, as I grow older and wiser, I often ask myself the question when I challenge something or find some problem with it. I ask myself the question, well, what if it wasn't there? What if it wasn't there? So Dr. Lowe would not be an ambassador to the WTO because when I graduated in 91, there was no WTO. We had GATT. There was a general agreement. That was not a full-fledged intergovernmental organization. So I think we first need to take a step back before we look at opportunities and really look at what we have and try to improve that. And that may be an opportunity. Thank you.
Maybe I can go next, and I'll do a potpourri of an answer to a bunch of questions. And I think I'll use the question about how do you increase investment as my jumping off point. And ultimately, investment is about risk and opportunity, right? Where there are huge markets and huge opportunities, say Brazil. Is an investment treaty really going to move the needle on a question on the investment threshold? Probably not. If you're a smaller country competing to attract investment, let's say you're Paraguay or Liberia, the availability of basic investment protections and the availability of a neutral forum, can move the needle when it comes to establishing the threshold for an investment. And that leads me to the questions of, well, why do investors abhor domestic legal systems? I think was a comment that was made, and I don't see that in my practice. Right, when there's a problem domestically, domestic courts will always be the best path for redress. Why? Right, you have a decree that effectively annihilates your business in that country. What do you as an investor want to do? You want to walk away and start an arbitration claim, and maybe 8 years down the road see some money coming out of it. Unfortunately for me, the answer to that question by most of my clients is no. Right? We want to go to the domestic courts because that's where we have the possibility of seeking annulment of the measure or trying to, save our ability to continue with our business, right? So why do you have that regime? Well, again, the regime, I think, is about the rule of law, and it's about the materialization of political risk. And when political risk arises, having as the only option to fight that fight in the jurisdiction where the political risk arose, can be daunting. We've seen, for example, in Mexico, the courts have been the first port of call for the political risk over the course of the AMLO regime, and has held up super well. But having that neutral forum available is, I think, a source of great comfort. And I always tell my students, that was, in fact, the whole reason behind diversity jurisdiction in the U.S., right, was the concern about, disputes involving people from different states, having a neutral place to go for those disputes to be resolved. Was the whole impetus behind that. But I will stop there and let others respond to the other 5 or so questions that were posed.
Very briefly, my first observation is not about the questions, but about what have been discussed on the ISCS. People talking about states' right to regulate, mostly from developing countries' perspective, but it does not happen all the time with respect to developing countries. For instance, there was the Philip Morris against Australia. That was because Australia adopted a plain packaging requirement on tobacco products. And very interestingly, it happens in 3 different channels: domestic channel up to the High Court of Australia, and the arbitration channel being procedurally rejected, and also the WTO channel being substantively rejected. And their respective issues are very different and very interesting. So first point, different international dispute settlement procedures can get involved in one single package of issue. And secondly, there could be developed countries being the target of the litigation. And thirdly, in the WTO dispute settlement procedure, there were 4 cases. All 4 cases were brought by developing countries against Australia. That was, of course, very interesting, mainly because of Philip Morris was behind these 4 countries. So this is first point. And second point about the very important and very difficult questions that you ask: how to promote international investment or trade, and at the same time to maintain sovereignty and domestic autonomous in promoting their policies. Very difficult question to be answered. How to balance? If you do it so strictly, then you scare away investment. And this also has to do with another difficult question about we are in the very challenging and interesting time. How are we going to address this? One thing that perhaps we need to be aware of is that even in your mind, it has been a firm rules in the international norms. In the future, there could be a very drastic change of those rules. So do not always believe that the rules that you are believing in nowadays will be the rule in the future. There could be a lot of new ideas, new disciplines be introduced into the whole regime. Thank you.
So let me respond to the questions of Tatiana and Carolina, trying to connect them. The question of, so what are the opportunities in this backlash? And then also what might be ways of fostering economic development? And so one interesting opportunity here is that some of the concerns of developing countries that have been basically raised as challenges to the neoliberal economic model and those institutions have been now taken up and advanced with full force by rich countries, right? By the US and Europe. And that's creating space for thinking about new kinds of policies. So if you think about the industrial policies of the Biden administration, the CHIPS Act, the Inflation Reduction Act, and of Europe, that opens up possibilities for developing countries to devise their own strategies as well. Now, that requires a lot of capacity as well, so it's not going to be easy, and resources, right? So it used to be that there was a taboo to talk about industrial policy. The slogan was, the best industrial policy is no industrial policy, and now what we're seeing is, what's your industrial policy is becoming the question, right? But developing countries dismantle their capacity. Many development banks went extinct. They really have stopped for many years thinking about this, because they were negotiating treaties and defending themselves against, complaints from investors and other trade disputes. And so the question is, how can you build that capacity? And also, can we think of industrial policies that are not just national, but could be regional, for instance? And I think one good opportunity to model that would be strategies to combat climate change that are clearly of interest to, all countries. And so how can we think of shared responsibility and policies that have to do with how you transfer technology, how you invest according to your possibilities? In other words, how can we model a response to a common problem with a regional, industrial policy? And so that could help to think, more broadly and further. But just to conclude, what I would say is that the current moment we're seeing today, this backlash, in my mind, is also an indictment of the failure of liberal democracy to create broad shared prosperity, right? And the hubris as well. And so I think that what we're seeing is the rise of autocratic regimes around the world that are obviously very concerning. So here's an opportunity to try to design a global architecture that could have effects on how that prosperity is shared, that could basically prevent or make more appealing liberal democracy around the world.
Regarding taxation, in my experience, when you want to sign a new free trade agreement, one of the first questions is about double tributation. It's very important. So you have to negotiate first that agreement, even before the free trade agreement. It's also important protection for investments, to be sure that you are going to invest in a country and it's going to be profitable because you want to do business. And you also ask about opportunities. What opportunities do I see? Well, I see a lot of opportunities in international trade because at the beginning, when we signed the U.S. Free Trade Agreement, Peru and the United States, it took 5 years between the negotiations, because people in Peru were afraid about the balance at the end, no? But nowadays, it's not like that anymore. We are negotiating treaties with India, China, and other big countries, and it is much faster. And as I see it, since a perspective of a developing country, there are a lot of opportunities that open international trade. And there are a lot of challenges also, because our countries mainly export minerals. So the challenge is to export manufactured products, to export services, and also, if we can do that, there is also going to be a growth in employment and GDP and economic development. That's why it's so important for a developing country. And at the end, the balance is also, it's amazing. We do not have to be afraid of signing agreements with other countries. That are my final thoughts. Thank you.
So many thanks to all of you for your insightful questions. Please join me in thanking our panelists for a very rich conversation today. I have one logistical announcement, which is the next session is at 1 o'clock back at Milstein East. It's the lunch talk by Professor Cass Sunstein on nudging, past, present, and future, but you do need to pick up your lunch on the way to that as well. Okay, so if you care about what lunch you want to grab, make your way up there quickly. But thank you all.